Okay, let's unpack this. We are diving into what seems like a pretty common problem, actually. Establishing liability when something gets damaged, say, in transit, but it's all sealed up. Nobody actually saw who broke it.
Right. And that's where the law gets interesting, because obviously someone should be responsible. The courts use this doctrine, res ipsa loquitur.
The famous Latin phrase, yeah. The thing speaks for itself.
Exactly. It's about circumstantial evidence. But, you know, it gets complicated fast, especially like you said, when multiple people handle the item, think manufacturer, shipper, buyer.
Which is precisely the situation in the case we're looking at today, Novak Heating and Air Conditioning versus Carrier Corporation. So our mission, really, is to follow the court's thinking step by step.
We'll start with the basics of negligence, then get into res ipsa, RIL, and apply its elements very carefully to the Novak facts.
And show you why pinpointing who had control and when is absolutely crucial in these kinds of product liability cases. Okay, so before we even get to RIL and circumstantial stuff, what's the absolute baseline? What framework does every plaintiff need to establish for any negligence claim?
Right, the fundamentals. You always need four things. Miss one, and the whole claim fails.
Okay.
First, the defendant has to owe the plaintiff a legal duty of care. Second, they must have breached that duty.
Standard stuff.
Third, that breach has to be the actual and proximate cause of the injury. And fourth, the plaintiff needs to show real, quantifiable damages.
And crucially, just because an accident happened doesn't automatically mean someone was negligent.
Absolutely not. That's a common misconception. The accident itself isn't proof. You have to prove those four elements.
Okay, that third element, cause, actual and proximate cause. Can you quickly break down the difference? Sometimes that gets confusing.
Sure. Think of actual cause as the but-for test, but for what the defendant did would the injury have happened? It's the direct link, sort of the factual chain reaction.
Makes sense.
Proximate cause is more about legal foreseeability. Was this type of harm something a reasonable person should have anticipated as a result of their actions? If the connection is too remote, too bizarre, the law might say, okay, you were negligent, but this specific outcome wasn't legally foreseeable. It cuts off liability.
So actual cause is the physical link, proximate cause is the legal or foreseeability link.
Got it.
You got it. So that brings us to the main event. What if you don't have direct evidence of the breach? Like Novak didn't see anyone at Carrier drop the HVAC unit. How does RIL help bridge that gap?
RIL is the tool for exactly that situation. It's a rule of evidence, specifically circumstantial evidence. It lets the court infer negligence.
An inference, okay. Not automatic proof.
Correct. It basically says, look, the circumstances surrounding this event are just so unusual, they strongly suggest someone messed up, even if we didn't see it happen.
And for that inference to be allowed, what specifically does the plaintiff need to prove? What are the core elements of RIL?
There are two main requirements, and you need both. First, the thing that caused the injury, the instrumentality, had to be under the exclusive control of the defendant at the time the negligence likely occurred.
Exclusive control. That sounds key.
It is. And second, the event itself must be the kind of thing that would not ordinarily happen if reasonable care had been used. You know, barrels don't just fall out of windows for no reason.
Right.
And the underlying idea, the policy, is critical here. RIL only works when control and likely negligence overlap perfectly with this defendant. If you can't tie the defendant exclusively to the instrumentality when the bad thing probably happened, RIL doesn't apply.
Okay, that makes intuitive sense. If multiple people had the keys, you can't just blame the first person. Let's apply this framework rigorously. Let's analyze Novak Heating and Air Conditioning v. Carrier Corp. First, what are the legally dispositive facts?
All right. So Novak, the heating company, ordered a big rooftop HVAC unit. It came from the manufacturer, Carrier. Carrier packaged it up shrink wrap, wooden pallets, the whole deal, and gave it to Yellow Freight, a trucking company, to ship.
Okay, so manufacturer to common carrier.
Right. Then Novak picked it up from Yellow Freight's terminal, still packaged. It wasn't until they got it to the job site and unwrapped it for installation that they found the damage, a severely messed up condensing coil inside.
Ouch. So they sued both Carrier and Yellow Freight.
They did, trying to cover their bases.
Makes sense. And what was the core legal issue the Iowa Supreme Court had to decide?
The precise question was whether Novak could use res ipsa loquitur to establish negligence against Carrier, the manufacturer, specifically when control of that unit passed from Carrier to Yellow Freight before Novak got it. The key was that the control was consecutive, not simultaneous.
One after the other. Okay, what rule of law did the court apply? State the full RIL rule again. and its elements.
They applied the standard res ipsa loquitur doctrine we just discussed. To succeed against Carrier, Novak had to show. Element 1, the HVAC unit, was under Carrier's exclusive control at the time the damage likely occurred. And Element 2, this kind of damage wouldn't ordinarily happen without negligence.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, exclusive control of the instrumentality?
Okay, so for Element 1, the sub-issue became, can you establish exclusive control when there are multiple defendants like this? The court, citing an earlier case, Town of Reasoner, said that for RIL to apply against multiple defendants, you generally need either shared control, like they were both managing it at the same time, or some kind of vicarious liability relationship, like employer-employee.
Neither of which applied here.
Exactly. Carrier and Yellow Freight had consecutive control. Carrier finished its part, handed it off completely to Yellow Freight. Yellow Freight then held it until Novak picked it up.
So the damage could have happened at Carrier's place or on Yellow Freight's truck?
Precisely. Because the damage wasn't discovered until Novak unpacked it, you couldn't pinpoint when it happened. Since Carrier didn't have exclusive control during the entire period, the negligence could have occurred specifically, the time it was with Yellow Freight. Novak failed to satisfy Element 1 against Carrier.
That seems tough for Novak. They get a broken unit, they know one of these two likely broke it, but because they can't prove which one, their case against the first one fails on this technicality.
It feels technical, but it's fundamental to RIL. RIL isn't designed to make two potentially negligent parties point fingers at each other. It's meant for situations where the circumstances point strongly to one specific party being negligent because they, and only they, had control when things went wrong.
So if the facts leave open two equal possibilities,
Then the inference isn't strong enough against either defendant individually. The thing doesn't speak clearly against Carrier if it could just as easily have been Yellow Freight.
understood. So element 1, exclusive control, failed because control was sequential. Now let's look at the second element. The occurrence would not ordinarily happen without negligence. How did the court's reasoning on that element play out?
Well, on its face, Element 2 seems met, right? Heavy, complex machinery like this shouldn't arrive with crushed coils unless someone was careless somewhere along the line.
Seems obvious, yeah.
But the failure of Element 1 really undermines the purpose of Element 2 in this specific case against Carrier. Yes, the occurrence suggests negligence in general, but because Carrier didn't have exclusive control when that negligence might have happened, i.e. during shipping, the occurrence doesn't specifically point the finger at Carrier.
Ah, okay. So even if negligence likely happened, RIL can't pin it on Carrier because the exclusive control link was broken by the handover to Yellow Freight.
Exactly. The inference of negligence couldn't reasonably be directed solely at Carrier. The sequential control muddled the picture too much for RIL to apply cleanly against the manufacturer.
And after analyzing all the elements, specifically finding that consecutive control broke the chain for element 1, what was the court's final conclusion regarding Carrier's liability?
The Iowa Supreme Court reversed the lower court's decision. They vacated the judgment against Carrier Corporation.
So Carrier was off the hook.
Yes. The court held that res ipsa loquitur was inapplicable against Carrier because the evidence clearly showed consecutive, not shared or joint control. Novak simply couldn't bridge that gap to prove Carrier was the one responsible using RIL.
Okay, let's connect this back to that earlier case the court mentioned, Town of Reasoner. That involved construction companies and a faulty sewer pipe, I think. What broader policy principle about multiple potential wrongdoers did the Novak court draw from Reasoner?
Reasoner is really important for understanding this limitation on RIL.
Yeah.
The policy it stands for is that you can't just sue two parties who handled something sequentially and say, well, one of them must have been negligent, so RIL applies to both, unless, again, they had shared control or some vicarious liability link.
Why not? It seems efficient to bring them both in.
Because, as the legal scholar Prosser pointed out, it risks improperly shifting the burden of proof. You might force a defendant, who is actually careful, to try and prove they weren't negligent, simply because they were part of the chain of custody. RIL is meant to help plaintiffs when evidence is hard to get, not to make it easier to sue potentially innocent parties in a supply chain.
So it protects defendants from having to disprove negligence when the plaintiff can't even show they had exclusive control at the relevant time?
Precisely. The risk of blaming the wrong party is too high if control wasn't exclusive.
Okay, let's try a different analogy to really nail this sequential control problem. Forget sewer pipes. Imagine a patient wakes up from a complex surgery with a weird burn mark on their leg. 3 people were involved sequentially: the anesthesiologist prepping them, the surgeon doing the operation, and the recovery room nurse. Why can't the patient sue all 3 using RIL?
It's the exact same logic as Novak and Reisner. Their control was sequential. The anesthesiologist only had control during prep. The surgeon only had control during the surgery itself, using specific tools. The nurse only had control during recovery.
Right.
If that burn could have come from, say, a faulty piece of equipment used by any one of them, or a chemical spill at any stage, well, the patient can't just use RIL against all 3. They'd need more evidence to show, for instance, this specific burn matches the heating pad only the surgeon uses, or it happened while under the nurse's sole care.
Without that specificity, pointing to the moment of exclusive control when the negligence likely happened,
RIL fails against the group. The sequence breaks the inference against any single party.
that really clarifies it. Okay, let's synthesize this. For the listener who needs to apply this, maybe they're dealing with shipping contracts, logistics, managing risk. What's the actionable step-by-step diagnostic checklist for spotting and analyzing a potential RIL issue with multiple defendants?
Okay, here's a practical sort of 5-step checklist for issue spotting these RIL scenarios. First, is there direct evidence? Did anyone actually see the negligent act? If yes, you don't need RIL. Stop here.
Simple enough.
Second, multiple defendants. Are there several parties who handle the item? If yes, bells should be ringing. Proceed carefully. RIL is much harder.
Okay. Danger zone.
Third, nature of control. This is critical. Was their control shared, meaning simultaneous, maybe joint venture partners, or was it consecutive, one after the other, like manufacturer to shipper to buyer? You have to analyze the likely time the damage occurred.
Got it. Shared or consecutive.
Fourth, apply element 1, exclusive control test. If that control was consecutive, like carrier handing off to yellow freight, RIL almost certainly fails against the earlier party, carrier in this case. Why? Because the plaintiff can't prove that specific defendant had exclusive control when the negligence most likely happened. The handover point is key.
That seems to be the main hurdle in these cases.
It often is. And fifth, conclusion. RIL is likely defeated in the consecutive control scenario unless there's something else going on, like a master-servant relationship creating vicarious liability, or proof they truly exercise joint control over the specific risk. Otherwise, the plaintiff needs direct evidence against a specific party.
Wow. So res ipsa loquitur, it sounds magical, the thing speaks for itself, but the legal reality is incredibly demanding, especially with multiple actors. It's not a shortcut for a weak case at all.
Not at all. It's a very specific tool for a very specific type of evidence gap, requiring that tight overlap of exclusive control and probable negligence.
Which brings us to the final thought for you, the listener. Given how Novak turned out, with carrier getting off the hook because control was consecutive,
What could Novak have done differently? Think practically. What kind of evidence, maybe contractual clauses, inspection procedures? What could they have insisted on before that unit ever left carrier's control? Or maybe before they signed off on receiving it from Yellow Freight that might have helped them pinpoint the negligence later? Something for you to mull over.
that's the real-world application. Precision in the law demands precision in your process. Know where your control and your liability begins and ends. Fantastic analysis. We'll catch you on the next deep dive.